On today's lecture video, which is part 2 series on second semester work on legal system and legal method, we shall be continuing our discussion on what sources of law. If you are lucky enough to have watched our part 1 series, we discussed these aspects as sources of law. We talked about received English law, we talked about Nigerian legislation, we talked about case law, customary law, Islamic law. Under Islamic law, I gave you people the types and how Islamic law is obtainable. And now, this place is very, very important because this is where the lecturer is going to use to test you as far whether you truly understand the sources of Nigerian law, or the sources of Ghanaian law, or sources of Zimbabwe law, or any other law you are watching for, or any other jurisdiction you are watching for. The whole thing remains the same, provided you were once colony of Britain or America or common law countries. Now, we are looking at what? Sources of law. Then, what we are going to do today is for me to clearly distinguish to you the difference between primary sources of law and secondary sources of law. Remember, these are the sources of law. Purely the sources of law we have. But for academic benefit, we have to know primary sources of law and secondary sources of law. Why? You see these two things here, primary sources of law, secondary sources of law. That is what determines how court is bound by law. Meaning that it is not the way this one binds the court, it's the way this one binds the court. And as a lawyer, if you cite this one, they have different implications. But now we are dealing with it as a student. What are we required to know? That is what this video is all about. By the way, my name is Kingsley. I'm currently in my 400 level finishing stage. What I do here is to offer lecture, notes, update, teachings, tutorial, and everything you could name of that enhance you towards passing your academic journey. If you are interested, which I know you should be interested, I encourage you to subscribe and like the video because every single Friday and Wednesday, we used to post a tutorial video like this. If you are interested in receiving one whenever I drop, who knows, that may be something that will aid you towards making excellence CGPA. Now, we turn our attention to what we have come to do. Primary sources of law. By primary sources of law, just like any name primary, when we say that something is primary, what do we mean? We mean that this thing is elementary. It is necessary. It is very, very important. That is what we mean when we say that something is primary, right? Primary sources of law is a composition of all those laws that the courts are bound in total to apply. It's an aspect that talks about the law, the books of law. Are we together? Why secondary sources? I want to juxtapose two of them so that it will be, I don't want to leave one and follow one fully. Now, one secondary source of law is basically about the book about the law. So, secondary sources is referring to books about the law, while primary sources is referring to books of law. Or see it this way. Primary sources is the law itself. Secondary sources is the thing that refers to the law or the thing that discusses about law. This board is a whiteboard. This thing is marker. This one, you use it to write on the board. The board remains the board, but this one is what I used to write on it. Two of them need each other. Same thing here. Primary law or primary sources is the main law, but this one is the one that describes. You could see this one as this ink I'm holding that I used to write, but this one remains the chief of everything. Are we together? Now, what have we come to do? Let us identify the types of primary sources of law. Here are they. Received English law is a good example of primary sources of law. Nigerian legislation is a good example of primary sources of law. Case law is a good example of primary sources of law. Customary law, I hope you can see. Customary law is a good example of primary sources of law. Islamic law is a good example of primary sources of law. Are we together? Now, why are they so? Received English law, if it applies, I have discussed what received English law is all about. If you don't know it, just follow this one after you go to my playlist channel or the link I will share at the end to watch it. Everything is on this channel, trust me. Now, when you are talking about primary sources of law, Nigerian legislation, like constitution, like this thing here, Freedom of Information Act 2011, is a good example of legislation. Are we together? Now, under these primary sources, they are called primary because whenever you cite them before the court and it applies to a matter before the court the court is bound by law to apply it. But whenever you cite this one, the court is not obliged to apply it. So when you say legislation refers to constitution and so many other acts. Now, when you talk about case law refers to the decisions of the court, which under hierarchy of court, the lower court are bound to apply it. I shall discuss it on part 3. When you talk about customary law, we all know what customary law entails. The rules of our people that are applicable provided they meet 3 doctrine tests, which I have discussed in previous video. when you talk about Islamic law, they are also applicable. Now, see how it works. So, whenever you cite any English law that has been in application from England in 1st January 1900, they are binding in Nigerian court, provided it is law that is from that time up to when we got our independence. Now, when you talk about Nigerian legislation, we are still bound by it. That is the constitution. Case law, so means whenever you cite them in court, they are primary. Primary means they are basic. So features of them means they are totally binding. I have said that. Books of law. They are the books of law. Whenever you are mentioning this thing now, this thing is books of law. Under here, we have something like, for instance, Section 3, Sub 1 of Freedom of Information Act 2011 say that an application for access to record or information under this act shall be made in accordance with Section 1 of this act. This thing is talking about the law as it is. So there are books of law. If you cite it like this, my lord, look at what Freedom of Information Act says. Don't you think I should apply it here? The court will listen to you. No matter whether, it's not about whether they like it or not, they must. But if you are talking about this thing is a textbook written by my own lecturer, Professor C.C. Obago. Now, this thing is purely legal method textbook. If you want to say, my lord, the Freedom of Information Act written by Professor Obiago say that for you to get this thing, you must follow this process. This is an opinion of my own lecturer, Professor C.C. Obago. It may be opinion of your lecturer, it may be opinion of Ben Wabeze, but they are what? Secondary sources. They are books about the law. This textbook I'm holding now, it is purely books about the law. But this thing now is the law itself. It is the books of law. Remember the difference. Books of law, books about law, they are different things. Are we together? If you have understood it, please like this video. Why this textbook is talking about what? Books about law. Now, they are purely persuasive. They are what? Purely persuasive. That is one thing you have to understand. They are purely persuasive. So, persuasive in the sense that it is not binding. If you cite any textbook, opinion of Ben Wabeze, opinion of any other author you could think of, the court is not obliged to apply it. It's just persuasive on the account of the author. The court in case of G.O. Ajebule and His Highness G.B. Usher made a very important point.
Law confusing? Let's make it simple. At lawmadesimplelegal.com, we break down the hardest legal concepts into easy-to-understand lessons. Whether you're a student, lawyer, or just curious, you'll find clear explanations and real case analyses across fields like criminal law, contract, tort, and constitutional law. This is where law becomes easy and practical. This platform was created by Kingsley Omenyi, simplifying the law for Nigerians and beyond. Visit lawmadesimplelegal.com or simply scan us on Google to discover how easy law can be.
The Supreme Court gave it as a warning in that case that why the opinion expressed in books about the law, that is secondary sources, textbook, and all those things, are persuasive on the account of their author. It should not in any way replace the fact that the lower court is bound by the decisions of the higher court. Because one of the issues in that case that a judge was being persuaded on the account of opinion expressed by a reputable legal writer. So even if when opinion of a legal writer goes contrary to what has been established as authority by the Court of Appeal or the Supreme Court, the lower court of hierarchy is bound to apply it. That one is bound to apply the decisions of the Supreme Court. In other words, if the authority in Supreme Court say that B should be A, and then opinion of textbook say that B should remain B, regardless of which one that is fair, which one that is right, which one is more clean, the decisions of the Court of Appeal or Supreme Court under the hierarchy of judicial precedent stands tall. That is it. Now we turn our attentions to what? Law journals. Law journals, we all know journals now. In journals, basically law journals, any opinion expressed by a writer, I have written many journals, I have partaken in many articles, I have written a lot in both the one of Southeast Journal, publication in my own scan, so many other things. Any opinion I express there, if you want to take it, you are taking it as an opinion about the law, but not the law. You can say Kingsley made a work that discusses on same-sex marriage issue, and Kingsley is a reputable person who has founded website like lawmadesimplelegal.com. Kingsley is a reputable person who has built a network across many platforms, YouTube, Instagram, TikTok, WhatsApp, and all those things. Yes, they can be persuasive on the judge on the account of my own legacy as someone who has contributed immensely to expanding the law or simplifying the law. That's remain persuasive. But the judge is bound to apply anything that is here, which may go contrary to the opinion I have expressed. Are we together? Now, we turn our attention against to what? Articles. Articles and law journals seem simpler this thing. Articles means brief writing, discussions. Brief writings are discussions. Any opinion you have expressed anywhere on the account of your reputation as a lawyer or as somebody who has made name for yourself is still persuasive. Then we have legal opinions, AG opinion. This one is very important because legal opinion in this case is not just legal opinion. Sometimes you see amicus curiae, friends of the court, people who come to court to support the court. They are not party to any case, but they are just there as an amicus curiae. Amicus curiae is what we call it in Latin, which stands for what? Friends of the court. There are some cases you read whereby issue between the AG of Federation and the AG of Abia State and all those. You see people volunteering themselves, amicus curiae. Sometimes the court can call on them, okay, you are senior advocate of Nigeria, we believe in your wisdom, can you come and address us on this or that? Any opinion you express there is mainly persuasive. The court is bound to take it or not to take it. Remember, the judge is standing as an arbiter. They don't delve into the matter. What they only do is to check the record of your antecedent and to know whether they should support your idea or not take it. That is what we mean by legal opinion. They are persuasive. Then we have newspaper, etc. Newspapers opinion. Of course, if you go to Guardian newspaper, Punch newspaper, you see people expressing legal opinions. All those things are what? Books about the law, but not the law. Now, on my first lecture video, I promise you that I'm going to give you guide as per how you are going to answer your question, right? This is how you are going to expect, or this is what you should be expecting. This is how it often comes. A lecturer, during my own time, a lecturer painted a question saying that there is a dispute between this so person, this so person. Choma cited Nigerian Constitution, Section 42, which is on fundamental human right to freedom from discrimination. Then Amechi cited authority in Okeje and Okeje, which state that nobody should be discriminated against on the basis of sex and all those things. Then Okafor cited the customary law of his people, who deals on the fact that a woman is not entitled to inherit any property, being that is a woman. Then Mohammed, also in the course of dispute, also laid emphasis as an amicus reference of the court on Quran provision as per sharing of inheritance. You see that now that, and then it is not yet over. Who was the name of the first party we mentioned? To be honest, I have forgotten. I just pray I remember. Okay, let me say now, Choma again, in support of the fact that he cited Nigerian legislation, also backed it up with opinion of Professor Ben Wabeze, which is an erudite person in constitutional law. Then in the course of it, Okeke to support his claim that woman is not entitled. I just pray that I'm not misplacing the name of this part. Okeke to support his claim for the fact that women is not entitled to inherit property under his customary law, cited an opinion expressed by one reputable person in their tradition, saying actually that women are not entitled to inherit their father's property. Now, if you look clearly to all these things, the lecturer may say, using the example of my own problem culture, the lecturer will be like, okay, examine the following and advise the court on the biasness of the authority cited. This is the cheapest question you could ever receive under this topic. Now, what you are going to do is to group the following laws cited and advise the court as per how they are going to be bound by those authorities cited. Are we together? So, when you come back to this thing now, you will be seeing that it's not something. Remember, you're no longer in secondary school. You not become and say tabular form, primary authority, secondary authority, okay, primary authority is this one, secondary authority. No. You'll be addressing it like normally raising issue, whether or not Okeke's position in Nigerian legislation is binding on the court in this case, as per section 42. Whether or not the customary law cited of this social community is effective in view of this. So when you group them like that, successfully, you can then interrogate them and say, okay, well, why we are dealing on this question, it is important to know that section 42 deals on discrimination, and section 42 is the constitution. So since section 42 is the constitution and by virtue of section 11 is the main law, that any other law that is inconsistent with it shall be null and void. You become pertinent to know that section 42 is standing tall as a primary authority. Then you come and interrogate also the authority on Ukeje and Ukeje. Ukeje and Ukeje is just an authority that says that women, any tradition, be it Igbo, Hausa, Yoruba, that discriminate against women is null and void when juxtaposed with section 42. Now, that you have cited case law, but you know that case law fall under primary authority. So you see that now, Trauma or any other girl that stand on this one is having a lot of authority on his side, on her side rather. Now, when you talk about customary law cited by Okeke, well, customary law, as I told you in my first part 1 video on this topic, is binding. But customary law is basically binding only to the extent that it doesn't go contrary to any other law, or it meets the test, the doctrine test of repugnance test doctrine, compatibility test doctrine, and public policy. If you don't know what I'm saying, go and watch that video. If anything I'm saying is sounding Greek to you, you are going to see it on this channel. The video deals on what? First lecture video on sources of law. Now, we have Islamic law. Yes, Islamic law is totally binding. So assuming any party cites it, is also binding. Do you understand? Unlike customary law, Islamic law is binding. So what you are going to do now is, customary law is also binding, please, but only when it meets the repugnancy test and all those tests are pointed out. What you are going to do now is that you advise the party according to the law cited. So you may know, it depends on how the question will come. If they say, tell the court on the bindingness of any law cited, you then know how you are going to say that this one is binding, this one is not binding, this one can be persuasive. Remember, they cited even opinion. Opinions are what? Like I told you, they are not binding. But on the account of the author, they may be persuasive. We have the case of Ejebule against GB Osha. That is a strong authority you can use. Are we together? And Professor Glanville Williams have once warned us that the law is that which is contained in a statute. And whatever that is not contained in the statute, but opinion of writers on textbook, are not the law. So these are the key things that will govern you when you are making reference to sources of law. And this is what they are going to test you, just the ability to distinguish where each one fall under and whether they are binding or not. By the time you are done with this test, it is expected that as a year 1 or year 2 student, you will then understand how the hierarchy and sources of law in Nigeria or any other country works. So I believe this helps you. The next thing we are going to do now is we are going to talk about the doctrine of judicial precedent. This is very, very important. So I encourage you to subscribe to this channel and stay tuned to next Friday, Saturday, and Wednesday, when we used to often post a video here. So it will be beneficial to you. However, if I am in my school, I wish to let you know that I'm running for the position of faculty president in my class, and your support will go a long way, so that the good work I've been doing here and the good work and the good intention I plan for Law Students Association of Nigeria will be materialized. Thank you and God bless you. However, if you missed that first video, I encourage you to click the link above. Any video you want to watch, just click it. It's going to be helpful. I will see you there. Like the video